Hello, everyone, and welcome to Uncivil Law. And by request of someone on the channel who sponsored this video, thank you very much. We are going to cover one of my favorite cases of all time. It's Justice Brandeis's opinion in the case of Whitney versus California. This, I think, is just the best opinion ever written. It is wonderfully beautiful. It is so good. It is the foundation of all First Amendment law as you currently know it. This one opinion by one judge is as good an explanation of the principles of freedom of speech as has ever been written by anyone in the history of time. It is that good, in my opinion. It can go toe to toe with anyone else's philosophical rationale. It is so good, and it fundamentally changed the Supreme Court's law. It wouldn't formally change it for a little bit while until a case called Brandenburg came along a little bit later. So this didn't itself change the law, but this was the foundation for changing the First Amendment law. This is the backbone of all First Amendment law, and it is just so wonderful. And I'm going to read it all. I'm going to read all of Justice Brandeis's opinion because it is just that good, and it's just moving in how good it is. So this is Justice Brandeis's concurring opinion, Whitney versus California. The year is 1926. Let's see what Justice Brandeis has to write. Miss Whitney was convicted of a felony of assisting and organizing in the year of 1999 the Communist Labor Party of California, of being a member of it and assembling with it. The acts are held to constitute a crime because the party was formed to teach a criminal syndicate. The statute which made these acts a crime restricted the right of freedom of speech and assembly, therefore existing. The claim is the statute as applied denied to Miss Whitney the liberty guaranteed by the 14th Amendment. Pretty clear fact pattern here. Miss Whitney wants to join the Communist Labor Party of California in 1990. She is convicted for being a member of the Communist Labor Party of California. And the Supreme Court is upholding her conviction. And so is Justice Brandeis, too. But he is laying down the foundations for why that conviction will not be valid now. So this is changing the entire way this is perceived. So let's read on to see what more he has to say. The felony which the statute created is a crime very different, like the old felonies of conspiracy or old misdemeanor of unlawful assembly. The mere act of assisting and forming the society for teaching this syndicalism of being a member of it or assembling with others for that purpose is given the dynamic quality of a crime. So here they're talking about some historical exceptions to which this does not apply. There are historical exceptions that are different. There is the felony of conspiracy. Conspiracy is still illegal. It's words that are integral to criminal conduct. There's unlawful assembly. It's still unlawful to assemble under some circumstances. Perhaps too many circumstances. I'm looking at you, New York City, and Bill Blasio, but that's still illegal. But here, that's none of those things. Here, this is a crime merely for being a member of a group, merely for assembling with others that is given the quality of the crime. So merely being a member is sufficient to be criminal, nothing more. There is guilt, although the society may not contemplate an immediate promulgation of doctrine. So even though there's no imminence, there's guilt. There is the accused is thus to be punished not for contempt of court or incitement of immediate violence or conspiracy for a criminal act, but a step in a preparation which, if it threatens the public order at all, does so remotely. This isn't contempt of an immediate situation. There isn't an immediate incitement, immediate violence. This isn't conspiracy to commit crime. It's just someone joining a group. If there's something criminal about it, it's so far removed. The novelty in this prohibition introduced in the statute aims not at the practice of the criminal syndicism, not even directly at the preaching of it, but merely at the association of those who propose to preach it. So that's how far this California law went. And it was held valid at the time because of how different the law has changed. But it's not the practice of doing it. It's not even the preaching of it. It's not even the proposing of preaching it. What's making this criminal is merely the association with people who are proposing to eventually talk about it. That's the criminal act. Merely being a member of a group who is contemplating at some point maybe advocating for something. And that's how far this all went. Despite the arguments to the contrary, which seem to me to be persuasive, it is settled that the Due Process Clause of the 14th Amendment applies to matters of substantive law as well as procedure. And, I still have problems with that. I'm with Justice Brandeis on having problems with that, too. I do it on Privileges or Immunities Clause, but we don't have to have the discussion right now. Thus, all fundamental rights comprised within the term liberty are protected by the federal Constitution from invasion by the states. The right of free speech, the right to teach, and the right to assemble are, of course, fundamental rights. They may not be denied or abridged, but although the right of free speech and assembly are fundamental, they are not in their nature absolute. Right, there have been exceptions, and there were exceptions here too. Their exercise is subject to restriction if the particular restriction proposed is required in order to protect the state from destruction or serious injury, political, economic, or moral. The necessity which is essential to a valid restriction does not exist unless the speech would produce, or is intended to produce, a clear and imminent danger of some substantive evil which the state constitutionally may seek to prevail has been settled. So in case you're ever wondering where that phrase clear and imminent danger comes from, I don't know if this is the first case to ever use it, but this is definitely the one that made it famous. There's only clear and imminent danger. That's the only rationale, according to Brandeis, that would restrict speech. And that's absent in this situation. So that's pretty potent stuff. It is said to be the function of the legislature to determine whether at a particular time and under a particular circumstance the formation of or assembly with an organization to advocate a criminal syndicate constitutes a clear and present danger of the evil. So he's saying it has been said that the legislature alone should define what are the circumstances for time, place, manner restrictions for an organization which wants to advocate for a criminal syndicate. And then acting the law here in question, the legislature of California determined that question in the affirmative. The legislature must obviously decide in the first instance whether the danger exists, which calls for a particular protective measure. But whether a statute is valid only in certain conditions exists, the enactment of the statute alone cannot establish facts which are essential to its validity. So if the statute is valid only in certain circumstances, then it can't be that the enactment of the statute alone creates its own validity. If this is valid because of the conditions, of the imminence, of the need, just because you passed it doesn't make it valid. Yeah, this is good stuff, man. Prohibitory legislation has repeatedly been held to be invalid because unnecessary, where denial of liberty involved was that of engaging with business. The power of the courts to strike down an offending law is no less when the interests involved are not property, but fundamental personal rights of free speech and assembly. Good stuff. The court has not yet fixed a standard to which the determined danger shall be deemed to be clear. Yeah, how do you determine if a danger is clear? How remote the danger may be, and still deemed to be present, and what degree of evil shall be deemed sufficient to justify a resort to abridgment of freedom of speech and assembly as a means of protection. To reach sound conclusions on these matters, we must bear in mind why a state is ordinarily denied the power to prohibit dissemination of social, economic, and political doctrine, which a vast majority of its citizens believe to be false and fraught with consequences. Okay, so he's teeing up the philosophical issue here. This is really good stuff. Pay attention to what he's saying. He's saying, look, we don't currently have a standard on what it means to be clear. How remote can it be? What degree of evil? How important does it have to be? He's hinting at ideas in here of what we would later call strict scrutiny. He hasn't gotten there yet, but that's what he's hinting at. How clear does it need to be? How present does it need to be? How bad does it have to be? And he's saying, okay, to figure that out, to reach the sound conclusion, we must bear in mind why ordinarily a state is denied this power. To figure out what these limits are, we have to figure out why ordinarily the state is denied the power. Why is the state denied the power to prohibit dissemination of social, economic, and political ideas, even where the vast majority of citizens believe it's false and fraught with even evil consequences? Why is the state denied this power, even if the majority believe it to be false, even if it's fraught with evil consequences? Why ordinarily are they denied that power? So then understanding that, then maybe we can talk about these issues that are left, but not without understanding the fundamental rationale of freedom of speech? Why is it fundamentally good? What is the foundational reason for it? Why does it exist? Those who won our independence believed that the final end of the state was to make men free, to develop their faculties. And that's the government. Deliberate forces should prevail over the arbitrary. They valued liberty both as end and means. They believed liberty to be the secret of happiness, and courage to be the secret of liberty. They believe freedom to think as you will and speak as you think are means indispensable to discovery and spread of political truth. That without free speech and assembly, discussion would be futile. That with them, discussion affords ordinary, adequate protection against dissemination of a noxious doctrine. The greatest menace to freedom is an inert people. Public discussion is a political duty, and this is a fundamental principle of American government. They recognize the risk to which all human institutions are subject, but they knew order cannot be secured merely through fear of punishment for infraction. That is hazardous to discourage thought, hope, and imagination. Fear breeds repression. Repression breeds hate, and hate menaces a stable government. The path to safety lies in opportunity to discuss, freely suppose grievances, and propose remedies. And a fitting remedy for evil counsels is good. Believing in the power of reason applied through public discussion, they eschew silence coerced by law, the argument of force in its worst form. Recognizing the occasional tyrannies of the governing majority, they assembled the Constitution so free speech and assembly should be guaranteed. It's hard to even know where to start in analyzing that as a philosophical rationale. It's hard to even know where to start. Those who want independence believe the goal of the state is to make men free and develop their faculties. Liberty is both a means and an end. A secret to happiness. The ability to think what you will and speak as you think are unavoidable, indispensable to discovering political truths. The greatest menace to freedom is an inert people. I mean, what do you even do with a line like that? How great that is. The greatest menace to freedom is an inert people. A people who aren't thinking. A people who are passive. A people who aren't engaged. The greatest danger to freedom is an inert people. Political discussion is a political duty. And they recognize the risks. But our founders knew that order cannot be secured merely through fear or punishment. And the reason they recognized it is because it is disastrous to thought, hope, and imagination and breeds repression. That hate itself menaces the stable government. That safety itself, that safety of the state itself lies in the opportunity to discuss grievances. So it's not even that you're trading liberty for safety. That's not even the issue when you're talking about freedom of speech and oppressing freedom of speech. It's not even giving up liberty for safety to oppress speech. You actually threaten safety itself. The safety of the state itself depends on free speech. That's his rationale, at least in part. The opportunity to talk about your grievances openly and find the remedy for the evil. The power of reason through discussion forbids silence forced by law. And recognizing that tyrants occasionally become a governing authority, they amend the Constitution so assembly is guaranteed. I mean, where do you even start with that? It's so good. It's so good. $35 from Jason McDonald. Thanks for sharing that. I couldn't agree more. Yeah, it's my favorite opinion. I mean, I'm honest to God crying because of how good it is. It brings me to tears because of how good it is. Fear of serious injury alone cannot justify suppression of free speech and assembly. Men feared witches and burnt women. It is a function of speech to free men from the bondage of the irrational fears. Speech frees you. To justify suppression of free speech, there must be a reasonable ground to fear that serious evil will result if free speech is practiced. There must be reasonable ground to believe the danger apprehended is imminent. Imminent. There must be reasonable ground to believe the evil to be prevented is serious. He's batting around the foundations of what will become strict scrutiny. This is the foundations of strict scrutiny. He's not using that language, he hasn't come up with it yet. But this is the foundation of strict scrutiny. The danger must be imminent. The danger to be prevented must be serious. Every denunciation of existing law tends in some measure to increase the probability there will be a violation of it. Yeah, if people are denouncing the law, people might violate it. No joke. Condemnation of the breach enhances the probability. Expressions of approval add to probability. Propagation of a criminal state of mind by teaching the criminal syndicate increases it. There are all kinds of dangers here. People are denouncing the law. People are denouncing the law. They're expressing approval of denouncing the law. They're propagating the idea. They're talking about undermining the rule of law. There's danger here. There's danger here. Advocacy of the law breaking still have higher. They're advocating for breaking the law. Still higher. Still higher. They're increasing the danger. And then he comes with the next line. Even advocacy of this violation, however, even if it's reprehensible morally, is not a justification for denying free speech, where the advocacy falls short of incitement. And there's nothing to indicate the advocacy would be immediately acted on. Yeah, there's danger. There's danger in this speech. People are meeting. They're advocating for breaking the law. They're advocating for it. They're preaching for it. They're encouraging it. They're forming groups to do it. It's dangerous. But it doesn't matter. It doesn't matter. Because it's not incitement. It's not immediate. It's not happening now. The wide difference between advocacy and incitement, and this would be a message to my friends on the more left-leaning aisle of the bench, who seem to think that these are the same thing, like speech is violence. Justice Brandeis disagrees with you. He says they're very different things. He says there's a wide difference between advocacy and incitement. Or to put it another way, there's a wide difference between speech and violence. There's a wide difference between speech and violence. There's a wide difference between advocacy and incitement. Advocacy is not incitement. Speech is not violence. They're two different things. You can advocate without inciting. The wide difference between preparation and attempt. There's a difference between preparing and attempting. There's a difference between assembling and conspiracy. Merely because you're gathered together is not conspiracy. There's a difference. They're not the same thing. Speech is not violence. And these differences have to be borne in mind. In order to support a finding of clear and present danger, it must be shown that either immediate serious violence was to be expected, or was advocated, or that past conduct furnished reason to believe that such advocacy was then contemplated. It has to be happening right now. It has to be shown that it's happening now. Speech in and of itself is not violence. You have to show more. And as good as everything I've been reading up to date has been, this paragraph for me is where it all comes together. This paragraph, let alone this opinion, this paragraph is the foundation of all First Amendment law. That's how good this paragraph is. That's how good this paragraph is. Justice Brandeis continues. Those who won our independence by revolution were not cowards. They did not fear political change. They did not exalt order at the cost of liberty. To courageous, self-reliant men with confidence in the power of free and fearless reasoning, apply through the process of popular government. No danger flowing from speech can be deemed clear and present unless the instance of the evil apprehended is so imminent that it may befall before there's an opportunity for full discussion. If there be time to expose through discussion the falsehood and fallacies, to avert the evil by the process of education, the remedy to be applied is more speech, not enforced silence. It's so good. It's so good. It brings me to tears. It's so good. It's 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 fundamentally correct. It's fundamentally correct. The cure for bad speech is more speech. The remedy for bad speech is more speech, not enforced silence. If there's time for discussion, then discussion should be allowed to resume, whatever it might be. Free speech must reign. And the ideas embedded in this are so fundamentally correct. It makes me weep. It makes me weep. I just so good. Only an emergency can justify repression. Such must the rule be if authority is to be reconciled with freedom. How good is that? How good is that? Authority must be reconciled with freedom. How good is that? Such, in my opinion, is the command of the Constitution. It is therefore always open to Americans to challenge the law abridging freedom of speech and assembly by showing that there's no emergency to justify it. Pertinent in our particular times as well, and people are challenging them, and good for them. Moreover, moreover, even an imminent danger cannot justify resort to a prohibition of these functions essential to effective democracy, unless the evil apprehended is relatively serious. So Justice Brandeis is going further. He's going further. Even imminence isn't enough. Even imminence isn't enough. Even imminence isn't enough. Even if it's going to happen right now, it's not enough. Even that's not enough if it's not serious enough. Freedom of speech is such a paramount value that even people openly advocating for things that are going to happen right this second will not justify oppressing freedom of speech unless it's sufficiently serious. And again, he's hinting at ideas that we later codify into an idea of strict scrutiny. We're talking about compelling governmental interest. This is the kind of thing he's hinting at. The kind of idea that's going to become developed. Even imminence isn't enough if it's not serious enough, or to use the language we use now, compelling enough. Imminence alone isn't going to do it for you guys. It needs to be something more. People meeting isn't enough. People advocating for breaking the law is enough. People preaching breaking the law. People condemning the law. Even if it's going to happen right now, it's not enough. If it's not serious enough. Yeah. Prohibition on freedom of speech and assembly is a measure so stringent it'd be inappropriate as the means for averting a relatively trivial harm in society. Yeah, freedom of speech is kind of important, guys. Society might be harmed trivially, but that's not enough. A police measure may be unconstitutional merely because the remedy, although effective, is unduly harsh or oppressive. It might work, but if it's too much, it's too much. A state might, in the exercise of police power, make any trespass upon the land of another of a crime, regardless of the results or the intended purpose. Right? It could just completely ignore private property rights. It might also punish an attempt, a conspiracy, or incitement to commit the trespass. But it's hardly conceivable the court would hold constitutional statute, which punished as felony the mere voluntary assembly with a society formed to teach that pedestrians have a moral right to cross unenclosed, unposted wastelands, and that advocate their doing so, even if there's imminent danger that would lead to a trespass. Yeah, so you might be able to, the state might be able to make trespass illegal. That seems like the kind of thing that the government might do. It might be okay for the state to say you can't cross another person's land. That sounds like something the state could do, even if it's regardless of the intent or purpose of the trespasser. Yeah, that's okay. Maybe the trespasser has a really good reason, but state, yeah, you probably can make that illegal, right? You can. It might be okay to make trespassing land illegal. That might be okay. It might also further punish attempt or conspiracy or incitement to commit trespass. That might be okay. Yeah, the attempt to do it, the agreement to do it, or the incitement to do it, that might be enough. But it's hardly conceivable the court would hold constitutional, which published as a felony, a mere voluntary assembly with a society that would teach pedestrians that they have a moral right to cross unclosed, unposted wastelands and advocate them doing so, even if it would lead to trespass. So all you sovereign citizens out there, get to meet and advocate for people doing really crappy stuff because of this. You have the right to meet in your groups and advocate for the right to travel, even though you're going to break all kinds of laws doing so, because Justice Brandeis says you do. And it's great stuff. The fact that the speech is likely to result in violence or destruction of property is not enough to justify suppression. Yeah, sorry. Just because the speech is likely to result in some kind of violence or destruction of property, that isn't enough. That isn't enough. There must be a probability of serious injury. Among free men, the deterrents ordinarily to be applied to prevent crime are education and punishments for violating the law, not abridgment of the rights of freedom of assembly. Among free people, the deterrents to be applied to prevent crime are education, more speech, and punishment. Yeah. If you want people to not do crimes, educate them. Punish them after the fact. But among free men, the remedy is not abridgment of the right of freedom of assembly. Man, that's really good stuff. Man. Lord. So here's what Justice Brandeis says. So Justice Brandeis says he's unable to assent to the suggestion that assembling within the party itself is not a right. So the majority opinion, because Brandeis is concurring, the majority opinion says being a member of this group itself is not within the scope of the 14th Amendment, First Amendment. So Brandeis says he disagrees with that. He disagrees with the idea that being a member of the political party is in and of itself illegal. The majority would say being a member of the party in and of itself is illegal. Brandeis says he wouldn't agree with that. Here's where Brandeis says. Brandeis says, in the present case, there's other testimony, and I skipped a lot of that, but in the present case, there's other testimony which tend to establish the existence of a conspiracy on parts of the members of the international workers of the world to commit serious crimes, and likelihood to show conspiracy be furthered by the activity of society. Under the circumstances, you cannot be served. So he's saying like there's other evidence that would get to the conspiracy. And whether or not that's true or not, I don't know. Doesn't really matter. I mean, it matters to Miss Whitney, but for our purposes, it doesn't matter. So that is our review of my favorite legal opinion of all time, Whitney versus California. Justice Brandeis writing, concurring opinion. I think it presents the basis of freedom of speech probably better than anything that's ever been written in the history of time. I can't think of any work of philosophy or work of by anybody who has presented a better, more cohesive, coherent, persuasive case than that. It is a thing of absolute beauty. It is a thing of complete and total wonderful beauty. And as I say, Justice Brandeis didn't win the day here. Miss Whitney did suffered the criminal conviction, and he voted to uphold the conviction for other reasons. But that opinion became the basis, basically in Brandenburg versus Ohio, is where that opinion becomes the majority opinion. And then from Brandenburg is entire rest of First Amendment law. So Brandenburg is where that formally becomes adopted, but Whitney versus California was where it was written first. And it's just so good. It's just so good. It's the foundation for the entire concept of freedom of speech. And he's handing out ideas of strict scrutiny, which he's talking about. He hasn't invented that language yet, but those are the ideas that they're talking about. I mean, it's so readily apparently true. It's hard to conceive how great it is. So, yeah, it's just amazing. So, I don't really have anything more to say about that case. It's just a wonderful thing. I encourage you to read it yourself and tell other people about it. It's so great. So, that's the end of our coverage of that case. Thank you so much for being part of the Uncivil Law family. I appreciate your continued support. If you haven't already done so, please subscribe to this channel, and you can also support us financially by clicking the applaud button below. Thank you so much for your contributions to our channel. It helps our work grow. Until later, cheers and goodbye.